members of the Higher Education Committee from the House and the Senate here together for this meeting. And seems appropriate, particularly today, that we'll start with a word of prayer from Chairman Jasper.
Let's all bow our heads real quickly, please. Dear Heavenly Father, thank you for giving us this day. Thank you for giving us this opportunity to be together and discuss important issues that are across our state. Help give us wisdom, and help especially give us compassion for those we work with and those around us. Do this work in your name. Amen.
Okay, the purpose of the hearing today, it's not about House Bill 51. It's about an update about where exactly we are in higher education in this state as respects sexual assault, sexual discrimination, et cetera, policies in our various systems. We have the university system, we have the technical college system, and we have the independent colleges represented here today. And what I'm going to do is let each group speak as to where they stand today. They've had revised policies since the end of last session when this bill was being heard in Chairman Stone's committee. And if members of the committee have any questions at that point, then we'll entertain them. And then after we're done with that, what I'd like to do is give a couple of comments about where we are going forward on this particular issue. So with that, the university system will talk first. If you would please come forward, introduce yourself to the audience, and we'll go from there.
Good afternoon. Chairman Miller, Chairman Jaspers, committee members. I'm Kimberly Ballard Washington, Associate Vice Chancellor for Legal Affairs and the University System's Title IX and Conduct Administrator. I began my legal career working on a college campus and have been dedicated to these issues for over 20 years. On behalf of Chancellor Wrigley and the university system, I would like to thank you for allowing us to share our policies with you today. In 1972, Congress enacted Title IX of the Education Amendments, which prohibits sex discrimination in any educational program or activity receiving any type of federal financial aid. In its inception, Title IX was interpreted as requiring educational facilities to provide equal access to women in athletics, equal facilities, equal scholarships, and other opportunities. In recent years, the interpretation has broadened to include sexual misconduct, reasoning that gender inequities might interfere with one's educational opportunities, and it extends past sports facilities. Prior to that time, the university system institutions addressed sexual misconduct under their non-discrimination and anti-harassment policies. I'd like to share with you today the action that the system office took in 2014 to address this important issue. In fall 2014, then Chancellor Hank Huckabee created a system-wide campus safety and security committee co-chaired by Georgia College and State University President Steve Dorman and Georgia Institute of Technology President Bud Peterson. The co-chairs named 3 subcommittees, one of which was the Title IX subcommittee. After several months of subcommittee meetings that included representatives from the university system institutions, as well as our colleagues from the Technical College System of Georgia and Georgia Independent Colleges, the Campus Safety and Security Committee report was presented to the board for approval in May of 2015. Included in that report was a recommendation to create a system-wide sexual misconduct policy and a recommendation to hire a system-wide Title IX administrator. Immediately following the committee's recommendations, we began the hiring process for the Title IX administrator and to create a system-wide policy to ensure uniformity, consistency, and best practices. In September 2015, I became the Title IX administrator for the university system. In March of 2016, the board adopted its first system-wide student conduct policy and sexual misconduct policy. The policies went into effect of July of that same year. Those policies provided a system-wide approach to ensuring safety on our campuses while protecting the due process rights of our students. When our system-wide policy was established, we knew that it would be an ongoing process and that changes would need to be made over time to ensure proper handling of these cases, utilizing best practices. Over the past couple of years, We've spent many days on university campuses conducting trainings and meetings with our campus Title IX coordinators, student conduct officers, panel members, investigators, and other professionals regarding procedural questions as these individuals worked through the 2016 policy. Through these discussions with our campus leaders, we identified areas where changes were needed and subsequently proposed changes to the policies dealing with student sexual misconduct and student conduct investigation and proceedings in August of 2017. These revised policies established increased oversight of student investigations by the system office and provide a more consistent approach for handling all student conduct cases across the university system. The 2017 proposals allowed for 3 changes: enhanced our focus on prevention and education to students, provided a single process for adjudicating all student conduct cases, and increased oversight from the system office. As you will readily know, these cases can be extremely complex, which is why increased oversight was so important. Our first change required that the Title IX coordinators and the EEO officers at our institutions report to the president or his or her designee, and to me as the system director for Title IX and student conduct. This reporting relationship allows me to participate in hiring and evaluation of those working in the area of Title IX. We also requested a change to have all cases which could lead to the suspension or expulsion of a student to be reported to our office so I can work with the institution to assign an investigator. In addition, I remain involved in the investigative process when appropriate to ensure proper adherence to our policies and to the law. This provides us with an increased opportunity to consult throughout the investigation process. Additionally, this change provides us with an opportunity to have ongoing review to ensure our policies are working effectively across our campuses. Our recent policy changes allow for a single process for adjudicating all student conduct cases, which includes allegations of sexual misconduct. The law stipulates that institutions of higher education must take appropriate action to ensure a safe environment to live, work, and study. Further, we are required to conduct prompt investigations when complaints arise. We're able to continue to provide this by using our subject matter experts to conduct the investigations. However, the adjudication of all cases are now handled by our student conduct offices. For more than 50 years, most institutions across the country have used their student conduct offices, their deans of students' offices, to conduct student hearings, ensuring that all parties are afforded due process rights. We want to allow both offices independently to use their expertise to do what they do best. By using the student conduct officers to conduct hearings in all student conduct cases, we're ensuring consistency of adjudications regardless of the alleged violation of conduct. Placing the adjudication of sexual misconduct cases with student conduct offices will allow our Title IX officers to focus more on education and prevention. Educating students early on the problems of alcohol abuse and sexual misconduct is critical, and we continue to require that freshmen entering the university system complete substance abuse training and sexual assault awareness education. Our Title IX officers will be able to plan and conduct more face-to-face campus trainings and activities, including bystander intervention. The hope is more preventative work will decrease the number of incidents relating to sexual misconduct across our campuses. Each Title IX coordinator is responsible for evaluating the needs of his or her institution for additional training. We want the coordinators to pay particular attention to the high-risk times of the year. Now, before I conclude, you may be aware that in September 2017, the U.S. Department of Education rescinded what has often been referred to as the Dear Colleague letter, which was issued in 2011 by the Obama administration. The U.S. Department of Education has indicated that they will issue new guidance in the coming months. Given the information that we have been able to glean from the current administrators in the Department of Ed, we believe our new policy is consistent with their direction. With that, Mr. Chairman and the members of the committee, I'm here to answer any questions you may have about our policies and practices in the USG.
Any questions from the committee? Number 15.
Thank you, Mr. Chairman. Thank you for that presentation. It was very comprehensive. I have a few questions. One is, can you elaborate a little bit on the prevention and education efforts that you're undertaking?
Our prevention and education efforts are primarily undertaken by our campuses. From our office, what we do provide is the Haven, which is an online tool that we use for sexual assault awareness, and also alcohol.edu. And for the last, I believe it's now going into the 3rd year, we have required all incoming students to go through those courses.
Okay. And are you tracking the numbers? And if so, are you tracking it by types of offenses, from rape to sexual assault, et cetera?
We don't track by the type of offense narrowly. We do track the numbers of cases.
Okay. Can you describe a little bit the adjudication process? You said that it goes to the student conduct offices. What is the composition of the panel?
The panels for any sexual misconduct case is always representative of only faculty and staff.
Okay. Thank you.
Yes, sir. Representative Hofstadter, or Senator Hofstadter.
Thank you for the presentation. You said, if I understand now, there's a single process that everyone would go through. Is that what you were saying?
There's a single process once you get to the hearing phase. For
Okay.
investigations, the investigations of sexual misconduct cases are handled by our Title IX coordinators' offices. And when the investigation is complete and it's ready to go to a hearing phase, it goes over to the student conduct office.
Okay. And what's the standard now that's being used? I don't know, is it preponderance of evidence, clear and convincing evidence?
We use preponderance of evidence.
Okay.
However, for cases in which it's a possibility of suspension or expulsion, our panels have to see substantial evidence. It's still preponderance, but they have to be able to articulate why they believe they have the preponderance.
Okay. And I know we've heard, and they may be isolated incidents in the past, but people not having the right to an attorney. Do they have the right to an attorney these days?
They do have the right to an attorney. Both parties, all parties involved can have an attorney present. However, the attorneys are not able to present on behalf of the student. It's a student process, and the students present for themselves.
So what does the attorney do there?
They are there to advise their client.
Okay.
Chairman Jaspers.
Thank you, ma'am. Appreciate it. I want to follow up on Representative Holcomb's question on the training. Is this, okay, when you're accepted to USG, how long do you have to complete the training before you're sent, someone at institution send an email or a notification that this person hasn't received both of these trainings?
I believe it's the first semester they go through, and I will have to verify that with the campuses, and each campus works with the Haven and alcohol.edu individually to set their standards. But I believe that we are trying to do it during the first semester. I know there are instances in which during the second semester students are still working on it.
Just seems to me like that's a little bit of a risky time then. I mean, just sitting here thinking about it, would certainly love to see that it be done
Earlier.
before the first day somebody shows up at a campus.
We are working towards that. We actually introduce it during orientation. But we do have some students that have not completed it by the time they arrive on campus, and we work with the campus leaders are working to get them to do it before the end of the first semester.
Okay, also, thank you, Mr. Chair. And on the investigators you described, just my curiosity is, how are they trained? What's the training guidelines that go behind someone who's an investigator in one of these very sensitive, tender situations?
Our investigators are trained by our office, but they also receive training nationally on standards of investigation and how to conduct investigations generally. We generally have student affairs professionals that have been conducting investigations of this type for quite a while, engaging in this. So they are accustomed to asking questions in the proper format, and also paying attention to body language and things of that nature.
So to be fair to say that anybody that's acting in the role as investigator could show chairman a certificate or some kind of, that they know what they're doing.
They should be able to show that they have attended and that we have deemed them to be
Certified.
be appropriate to conduct investigations.
Thank you. Thank you, ma'am.
Representative Reeves.
Thank you, Mr. Chair. I have two questions. The first is dealing. You were talking about the conduct office, and that the evidentiary standard is preponderance of evidence, and that you said if it was an offense that could result in, I think you said expulsion or suspension, that they had to find substantial evidence. Let me clarify. That does not shift the burden of proof, though, right?
That does not shift.
So how do we determine that the evidence was substantial? Does the finder of fact simply make a finding that we find that the evidence was substantial? I mean, how is it decided that this was substantial evidence as opposed to not substantial?
What we are asking our finder of fact to do, to be able to articulate what it is that pushes them over the edge. You know, preponderance is really 50% plus.
Yeah, sure.
Plus shouldn't be a gut feeling. Plus has to be something.
Well, and isn't that what clear and convincing? I mean, isn't that what clear and convincing is?
We don't think so, sir.
Really? Okay. Because that's what I think clear and convincing is. As a practicing attorney, I mean, that's the difference between preponderance and clear and convincing. I mean, what you just said, but I'm not trying to be antagonistic. The other question I have is, talk to me about the level of review or appeal. What is a person's rights if they disagree with the finder of fact? What are their rights of appeal and review on this?
The first level of appeal would go to the Vice President for Student Affairs in most cases. Could be to the Vice President of Academic Affairs if we're dealing with a faculty member, but generally Vice President for Student Affairs. And either party can submit an appeal. And if the party is unsatisfied at that level, then they can appeal to the President. And the last level of appeal in the system is to the Appeals Committee at the system.
Okay, so is there any route, if you go through all of those levels of appeal that you described, is there any route that ultimately can land you in Superior Court?
A person generally has the right to sue if they're not satisfied or they think that the institution has done something inappropriate to them. So, yes.
You bill at 6-minute intervals, and I'm going to have to go on to somebody else, okay?
Okay,
Okay.
fair enough.
Thank you. A little humor out there for you folks. Okay. Senator Orrock.
Thank you, Mr. Chairman, and appreciate the chairs calling this hearing today. Thanks for your testimony. And just briefly, as we have many more lined up to bring information, you detailed how the Dear Colleague guidance letter was rescinded by the new folks at the Federal Department of Education, and that they're going to be there's going to be a rulemaking process. You all have just positioned, added some bells and whistles and streamlined your approach, thought it through. How's that going to work? Should we be in a posture of, let's see what the Federal Department of Education is going to be moving
We're going to cover that in a minute.
That's my question.
Okay. We're going to cover that in the committee in a minute. We'll cover that. You don't have to cover that. You're off the hook on that one.
Okay. Right?
Yes, sir.
Thank you, Mr. Chairman.
Yep.
Preponderance of the evidence standard, that's prescribed by federal law, right?
It is.
Okay, so
Well, prescribed by federal law for Title IX cases?
Title IX and Clery Act, right, requires preponderance of the evidence standard to be applied.
At this point, the guidance from the Office for Civil Rights is preponderance. You can choose whether it be preponderance
Beyond,
or
that's correct.
beyond.
Okay, so
I've got 'em.
What guidance is that?
That's in the September 2017 rescission of the Dear Colleague letter from 2011, they gave some questions and answers, and so the new guidance says that institutions can choose.
Ms. Ballard Washington, I'll give you a copy of that. I've got a copy of it. I'll be happy to share that with you. It gives you a definition of what you're looking.
Let me just ask one follow-up question, though. That wouldn't supersede, though, Title IX and the Clery Act, a guidance letter, right?
No, it would
Okay.
not.
And-
I would not think so.
Preponderance is in the
Yes.
Clery Act and Title IX, right?
Yeah, it's in the Clery.
Thank you.
Okay, just one or two more points, then we'll let you go. I believe it was Representative asked down there about the categories of offenses, and that you said you'd keep numbers, but you don't keep of categories.
Right.
The type of assaults, et cetera, rapes, et cetera. We don't get that information from our institutions?
We have that it's a sexual misconduct, and we know when the cases are coming in, when we're talking to the institutions about it, of course, we know what the allegations are.
Right.
So the campuses know, but our outline is the numbers. What we're keeping record of is the numbers, and we categorize broadly with sexual misconduct.
I guess my question would be from a standpoint of where we are and how well we're doing and what kind of effect we're having with our training and so on and so forth. Are our numbers going to be going down by various categories, just like we do for everything from crime here, like, for example, whether it's in DeKalb County or the city of Atlanta, assaults, burglaries, larcenies, et cetera. It seems to me we would want to have that information going forward.
We can absolutely get that information. What we are getting at this point is the cases that rise to the level of suspension or expulsion.
I know, I understand. I guess the reason I say that to you is the fact I think the public's going to want to know that.
Okay.
Particularly if they see that if there's an incidence of certain types of cases at a certain institution, I think a mother and father are going to not know about that type of thing before their child goes to that institution.
Absolutely.
The other thing I would say to you that, and I don't think I've seen it, and I've been down here a few years, and so has Senator Warrock, I don't think we've ever seen a report that's come through the committee structure that see what you're doing in this area in a given year. I think it might be helpful as we go forward in this, because it's obviously an issue that's not going to be going away, that it would be very helpful if in the future when I assume you do an annual report, that if we could see that.
We will provide that.
Okay, thank you very,
Thank
very
you.
much, and thank you for your testimony.
Thank you.
Okay. Next, we're going to have the Technical College System of Georgia. Ms. Linda Osborne Smith is going to speak, I believe.
Hi. Chairman Miller, Chairman Jaspers, thank you so much for the opportunity to address you today, members of the committee. I'm Linda Osborne Smith. I'm a Deputy Commissioner with the Technical College System of Georgia. And what I'd like to do today is give you just a brief overview of our system. It does differ somewhat from the university system. And then just give you an outline of our policy for addressing sexual assault complaints on our campuses. As most of you in here already know, our primary mission is to provide a trained and competitive workforce for the state of Georgia. And we do this through our 22 colleges and our 85 campuses across the state. And the majority of our colleges are commuter colleges. We have 2 that do offer student housing. They can accommodate about 300 students between both colleges. And I'd like to point out the average age of our student is around 27. Through our adult and our technical and our customized business training, we serve more than 200,000 students across the state. We fully recognize that our ability to fulfill this mission is contingent upon our ability to provide a safe educational environment for our students, for our faculty, and our administrators. So to this end, as Kimberly alluded to, we are focusing efforts on creating awareness and preventing sexual assaults. At all of our 22 colleges, we provide training to all new employees and all new students on how to report sexual assaults, and most importantly, how they can be prevented. In 2017, we had a total of 6 sexual assault complaints across our 22 colleges.
Wow.
When we receive a complaint of this nature, our policy requires that we first notify the individual, you have a right to file a criminal complaint with law enforcement. Our policy also requires that we provide a list of resources, such as counseling or medical treatment to these individuals who file these complaints. We don't currently have in-house resources to provide those, but we work really, really hard with our communities to make sure that we have that information very accessible and help our students. Regardless, though, of whether or not that individual chooses to file a criminal complaint, our policy requires that we conduct an administrative investigation. That investigation involves interviewing both the complainant and the respondent, any witnesses that may be identified, and it requires that any other evidence that may be available be evaluated. And our goal is to complete this investigation within 30 to 45 days. At the end of it, we provide those findings to both the complainant and the respondent. If the investigation has substantiated the complaint, it's at that time that the college will initiate the disciplinary proceedings in accordance with their student code of conduct policy. The policy requires that we provide students with a written notice of any disciplinary charges against them, and also notify them of what sanctions are being proposed. It requires that colleges provide an opportunity to that student to respond to those charges before any sanctions are imposed. In addition, if the sanction, the proposed sanction, is a suspension or expulsion from the college, we require that colleges provide a hearing to that student before the sanctions are imposed. After the hearing, the student has the ability to appeal the sanction to the president, whose decision is final. To improve on this policy, just this year, we are going to move to a system-wide investigative model. You saw from the numbers, we believe that one position can easily handle the volume. So we're currently recruiting for an investigator that's going to be responsible for investigating not only sexual assault, any type of sexual misconduct, including sexual harassment, at all 22 colleges. Our purpose in doing this is we want to ensure that we have an individual that's experienced in these types of investigations and that has had the training. We want to remove any question about the objectivity of the investigation. And we want to make sure that we have a consistent protocol across all 22 colleges. We've written this policy to be compliant with Title IX as well as the Clery Act. I want to reassure this committee and everyone that campus safety and the well-being of our students will always be top priorities with the technical college system. And we believe that this policy reflects that commitment, and it also reflects a commitment that we will treat our students fairly and that they will be afforded due process before they're denied an educational benefit. And I hope the information is helpful to you. I know it's been brief, but will certainly entertain any questions that you might have at this time.
Representative Holcomb?
Thank you, Mr. Chairman. Thank you for your presentation. I have a couple quick questions. One is, you mentioned prevention being a focus. Can you describe a little bit about what you're doing in that
Yes,
space?
we also have contracted for the Haven training. And it's an online training, and we do make it part of the new employee and new student orientation.
Anything beyond that?
Some of our colleges continue with awareness campaigns that educate students further on bystander intervention and other, we have the drug and alcohol abuse awareness training as well.
Okay. For the investigators, do you know, and certainly this would be something that I think would be needed by the person that may be hired, if they have training in the neurobiology of trauma, which is very important for victims of sexual assault or rape?
I'm not aware of that, but you've certainly put it in my mind that we maybe need to add that into our selection process.
Good. And then lastly, my wife's from Reedsville, Georgia, and so I'm familiar a little bit, even though I'm from Atlanta, with rural Georgia and the resource issue. And you did mention that. And are there any gaps where there just aren't resources available for medical attention, say nurses, et cetera, if somebody is the victim of sexual assault or rape at any of our technical colleges across the state?
We've not experienced that when compiling the resources or making referrals, but I can certainly see in some communities that might be a gap.
Thanks.
Senator Jackson.
Thank you, Mr. Chairman. Thank you for being here. You mentioned that in 2017, there were 6 sexual assaults on your campuses. Is that consistent with the past 5 years, or has that number gone up or down?
There were 6 sexual assault complaints on our campuses. I don't really have the data for the previous years. I track both. I can get it for you. We maintain that data in our annual security report, but I don't have it right now.
Okay, thank you.
Chairman Jasper.
Yes, ma'am. Ms. Smith, I hope you'd share the with the committee. I'd like to see a security report. Never seen one before. I think it'd be something we might.
You know, they're actually online. We file it every year in October with the Department of Education.
Share that link
But
with
we
us
can
and
share
we'll-
that link with you, absolutely.
When Representative Holcomb, you and I must be just like thinking on the same wavelength here. Yeah, I know. Well, I don't know about that. But, you know, again, I'll ask you the same question I asked USG was, you know, on this training, you said part of, I guess the first part of just getting there, do you require it to be done before classes start too? What's your thing on this, on your training?
You know, our students are with us for a short time, so it does make sense before they come on campus. We don't currently have that in place. We would like to, but we don't currently require that it be done before they come on campus.
Okay.
We have a lot more control over requiring the employees to complete it.
Well, certainly. And on the administrative investigators that you use now, you know, who are they? I mean, are these, and how are these people trained? I understand the person you're going to hire will have much more developed criteria, but
We actually brought in a national organization that's recognized. I think it's called ATICSA, is a professional organization of Title IX coordinators in higher education. And we brought that group in and trained individuals from every one of our colleges. So they do have the certificate that they are Title IX investigators. They just don't, they're not called upon to investigate these types of complaints that often.
fortunately.
Fortunately, thank God.
Thank you, Ms. Smith.
Pat, are you 20? Who's 27?
I am.
Oh, go ahead. Good, George.
Thank you. Am I on?
Yeah.
One of my questions was what Chairman Jaspers just asked. My other one is just to say this: I'm amazed that you only have such a few number of sexual assaults on your campuses. And I know you've talked about prevention, and I assume the age of your students would have something to do with this, but what else has something to do with that?
I think the fact we do not have student housing. We don't have some of the student activities that your four-year colleges typically have. Many of our students have jobs, and they're coming to college part-time. And they're not on our campuses a lot. You know, they come and take their classes and go home.
That's right.
And I think that may contribute to it.
That's okay, good. I have one question, and I apologize, I should have asked Ms. Ballard Washington the same question. You know, we keep increasing dual enrollment in this state, where now we have all these high school young people on our college campuses, technical colleges as well as the university system. And do we have a way to deal with this, bringing these young people in? You know, obviously we're having classes for our students and such, and I'm not trying to, it's necessary we have to deal with it, but we continue to grow this, and I have a feeling in the next decade we're going to see more and more young people that are going to be taking advantage of Move On When Ready, which we now have dual enrollment, whatever you want to call it, simply because of the fact that if they do it right, they can start as a sophomore in college and alleviate some of their parents' student debt. But I do think that this is going to be an issue going forward, and I'd like to ask that you all think about that down the road. You probably already have. I don't mean to be presumptuous, but, and Susanna, you can comment on it too as well, but I do think this is something that we've got to be think about going forward. I just don't know if we've done anything at all in that area.
Well, our policy requires the investigation of any complaint. If it involves individuals who are younger than 18, then in accordance with Georgia law, we're mandatory reporters.
Right.
So we would also report that to the Department of Family and Children's Services. But one additional step that we take, because the K through 12 schools are also subject to Title IX,
Right.
we reach out to their Title IX coordinator
Okay.
and will typically do a joint investigation.
Okay. Similar for the university, I assume?
Yes.
Okay.
Very similar.
And I noticed you said the mandatory reporting, that's probably, I've got all these lawyers in the room, correct me if I'm wrong, that's the only case I think that we have in the justice system that mandatory reporting is just for child abuse, I believe. Is that not true? Is there any other mandatory reporting that someone has to do other than a child abuse situation that you're aware of?
I'm only aware of the
Okay.
child abuse.
Okay, thank you. And I'm sorry. Now, Pat, you're getting close to home there. And elderly abuse too, I'm sorry, that's another one, okay.
Oh,
Okay, well, thank you very much.
thank you.
I'm sorry, pardon me, I'm sorry. Go ahead.
Thank you, Mr. Chairman. Thank you for your presentation. I'm just curious to know if a student should need assistance with mental health counseling. You know, we having a conversation about sexual assault and harassment. I think mental health plays a part in that as well. If a student should feel they need that, do your schools have those type of services available?
We have a disabilities coordinator at every one of our colleges. And once a student self-identifies as having a disability, including a mental health issue, our job is to accommodate that, to ensure that they have the same access to education. Does that answer
Yes.
your question?
It does. Thank you.
Okay. Thank you very much.
Thank you.
Dr. Baxter from the Independent Colleges.
Thank you. My name is Susanna Baxter, and I'm president of the Georgia Independent College Association, and I have the honor of representing 24 of the state's private not-for-profit colleges. You have in your folder our latest publication, hot off the presses. You can turn to page 4 and see a map and a listing of the campuses that we serve, as well as a lot of other information about our sector. I'm here today to talk to you about compliance in a private college setting and how it might differ. Now, federal Title IX law applies to both public and private institutions. So in large part, I could say ditto to what was said previously, but there are some distinctions, and they're important distinctions that I want to make. First, let's talk about due process. That's common in our vernacular. We talk about that from a higher ed perspective. We mean the student knows that there's a hearing, the hearing is held, and they have a right to appeal. And those are, within the due process world, a student who was unhappy and felt that due process wasn't served, because that's a constitutionally afforded right, would sue the public institution for not following due process. From a private college perspective, we don't have due process. What we have is fair process, and it's an important legal distinction because a private college student will look at our student handbook And the faculty and staff will look at our policies and procedures for them, and that becomes our contract with the student or with the party as to how we're going to handle these cases. And so from a private college perspective, our institutions do have a fair process, and any student who feels that the process didn't follow the policy would sue us on the grounds of a breach of contract. So that's an important distinction in our conversation. Title IX instructs campuses on how best to provide a fair process for sexual misconduct cases, which also include sexual assaults. I want to talk to you briefly about the regulatory structure so you can appreciate what's going on. I like to picture it as a three-legged stool. And so you have Title IX, Clery Act, and the Violence Against Women's Act. And all three of those inform how a campus does prevention work, how they handle adjudication, how they handle reporting of that. Like in the Clery Act, that language is available as far as reporting so that parents, that's exactly why it was put up after the murder of Jean Cleary, so that parents would have access to information as to what was happening on that campus. Both public and private report that level of information, and it's publicly available. Those are the laws, if you will. And then above that are the regulations. So the Department of Education promulgated rules based off of those laws to let higher education know this is what we mean by this law. Now, it might come surprising, but sometimes federal regulations aren't clear. And in that case, what you have is the issuance, and in this case, the Department of Education issued a Dear Colleague letter or a guidance document that is, in its best, rooted in the regulation, which is rooted in the law, and it's all connected. Now, as we've heard earlier, the guidance document has been rescinded, and the latest ones that came under the Obama administration, but you still have the regulation that we have to deal with as well as the law. There is not a lot of leeway. There's not a section that says, you know, turn to page 45 if you're a private college and you're done if you're public. It's not that way. It's across the board. But there is a little bit of leeway. So I just want to give you an example, and you've heard it already today in the prior testimony. One institution may have more levels of appeal than another. The important part is you have to have, for a fair process, the right to appeal. So a person can appeal. Typically, it's in a smaller institution, in a private college setting, a smaller institution that doesn't have that big of an administrative staff, there's not that many levels, you're going to have very few appeals. For a larger institution that has more a hierarchy, you're going to find more appeals available to the student as a general rule of thumb. Another opportunity or that schools can deviate on slightly is on investigating. So an institution could, in private college world, this happens quite a bit, might hire an outside investigator, typically a lawyer, to come in and handle the really tricky cases. Or they might look to an internal investigator that's already on staff to review those cases. What they can't do is not investigate. The law says you have to investigate. They have an option as to who they bring in, but again, the law says they have to be trained. And so all of our investigators are trained on the private colleges. Another opportunity for deviation is within mandatory reporting. Some institutions, some private colleges in this state do require mandatory reporting. Most, the vast majority, do not provide mandatory reporting. Title IX, though, requires the institution to inform the student of the option to report to police, that is a viable option, and that in most cases our institutions encourage them to do so. But an important distinction is that the majority of students, the vast majority of those students, turn down that option and do not want to go to police. Now, you've heard a good bit about prevention, and I just want to toot our horn because you should be proud of the state of Georgia and what we're doing in prevention. In 2016, the Georgia Independent College Association received a grant from the Health and Human Services Department Office for Women's Health. It's a multi-sector grant. We wrote it to be inclusive of our colleagues in the public sector. And we really have formed a very thoughtful, research-based group to look at the area of prevention. There is not a great deal of research nationally to understand how do you address prevention of college-age personnel. We know far more about if I wanted to stop a student from drinking alcohol irresponsibly. There's a whole lot of literature to tell me how to do that. There's very little on sexual assault at this age group. And so the federal government has put resources in trying to come up with what are some of those model programs. And Georgia is at the table. And I'll tell you, among the 13 grantees across the country, we're the only state that came to the table with all sectors represented. And so I'm very proud, and you should be proud, of the work that we're doing. Now, as a piece of this, we have created a statewide coalition to focus on campus health. We've had 2 meetings so far. Over 100 college personnel have attended these meetings, representing over 33 institutions across the state. We are committed, both public and private, to stopping the epidemic that we hear about of sexual assault and that students experience. We don't want that to happen. We want to be a part of the solution, and we are a part of that solution. We also, as you heard, we collaborate on alcohol and other drug and sexual assault prevention at the student level. So those dual enrollment students that you asked about, those students are required, because they're matriculating. It doesn't matter how they matriculate. Right. They're required to take Haven, and they're required to take Alcohol EDU, depending on which campus they attend. In fact, we included that in the form the parent signs off of at the Department of Ed. We included that because we felt that might give some parents heartburn to know their student would have to take that module.
I'm going to stop you right there. You require it. Does the university system require it as well?
We do. We require our Move On More Ready students to go through the same process.
Okay, thank you.
From USG, you required at what point?
It's required once they go through orientation. It's part of orientation, but not everyone completes it during that time frame.
But wait a minute. Let's back up. I'm talking about kids in high school now.
Yes, but they have to go through an orientation piece also as they're coming into the course. It's not the full orientation, but they are oriented into college.
No, I understand. Let me back up. If we've got a high school student coming on our campus, when do you require it?
It's going to vary across campus. The best practice, you would really want to have the course taken within the first 6 weeks, if not before they matriculate.
Okay.
It's tricky sometimes because we have a lot of open access schools, so some of those students don't decide till August till they're coming. And so it's hard to get it in before they arrive on campus. One way to have students take it for sure, because you don't have a mechanism except, come to class and pull them out, is to not let them register for the second semester. And so some institutions have used data to help flag that record to say, we wanted you to take it, you were required to take it, you didn't, so we're not going to let you register for courses until you sit down and spend this 30 minutes or an hour, I can't remember how long it takes, to go through this module.
It seems to me if we're offering dual enrollment to high school students, then we make it a requirement that they do this as soon as possible before they matriculate. I have a hard time understanding that. We're giving people increased opportunity, and if it's 30 minutes or an hour, I can't believe that we can't make that work for these dual enrollment students. That's just an observation, something to think about. Thank you. I'm sorry, Susanna, go ahead.
No, that's fine. So the bottom line is that private colleges base their sexual misconduct policies on federal law and regulation, which means that it affords a fair process to both the complainant and to the respondent. And I would welcome any questions you have.
I think you got off easy.
I think I did.
No, we didn't. I didn't hit it fast enough. I'm sorry.
Run.
Thank you, Mr. Chairman. I would just like to know, as both other groups have stated, just any of the data behind the numbers, any trends that you're seeing across your campuses.
I have heard that there has been an uptick as we are talking more as a country on this issue, that there's been more students coming forward within the Me Too movement that we would anticipate. I have not seen the latest Clery data, and the Clery data it's behind, and I have not collected from the campuses to see where we stand on the Clery reporting data. So it's all anecdotal at this point. I will just say for the record, when an institution is really doing a good job at both prevention and education, then students know where to go when they need help. So you would anticipate that a well-implemented program is going to see initially an uptick in reports because students feel safe in coming forward. And that was a lot of the purpose behind the Title IX reshaping that process, because there's a requirement that we have to tell students where they can go.
Chairman Jaspers.
So I'm going to ask you a question because it'll bother me tonight at 3 o'clock in the morning. So, Dr. Baxter, just explain for me as a non-lawyer.
As a real
For me
person.
as a non-lawyer, and there are 5
We
lawyers.
call those real people.
There's 5 lawyers on this
I'm a
committee.
non-lawyer. I should have said that from the
I've
beginning.
got 5 sitting around me, so they'll probably come up to me and explain it to me afterwards. But just give me a real-life experience, the difference between a fair process and a due process.
It's a legal distinction. So a number of our policies are going to look a lot like what you see at the university system across the campuses. It might look, trained investigators, it's going to look very similarly. But legally speaking, a student attending a private college doesn't have due process rights, because that only exists if you attend a public institution, because it's a constitutionally afforded right. Fair process or having a breach of contract is where a student would go to seek remedy if they've had an issue at a private college. It's a legal distinction.
You can see me going, but they have constitutional rights as just individuals. And
So
you know,
I'm not an attorney, but they don't have due process rights.
they're looking at me grinning like, shut
Yeah,
up, Rick.
they're a private institution, so they don't have due process rights, but we are committed and believe that the steps that we commonly refer to as due process and we refer to as fair process are good processes to have. And so our institutions have those, but we don't call it due process.
All these lawyers are now billing you up here. Okay, Suzanne, thank you, Dr. Baxter.
Thank you.
Couple of comments. Title IX really means everyone's afforded an educational opportunity without being discriminated against on a sexual basis. But I think the Clery Act we've talked a little bit about here, and this is one of the things in the Clery Act I found was interesting, that institutions, this is for federal aid, institutions have to disclose campus crime statistics and about security policies. And I believe, Sandy, you mentioned the Violence Against Women Reauthorization Act. That requires institutions to have statistics for incidents of dating violence, domestic violence, sexual assault, and stalking. So that sort of gets back to the categories that I asked the question about. And if we have to do that for the Violence Against Women Reauthorization, I think we ought to have that available for the public as well. It was mentioned earlier, Senator Orrock asked a question, and as mentioned earlier back in September, the new Education Secretary, DeVos, she basically did away with the President Obama's administration's, she rescinded their guidelines, if you will, back in September. And at that time, it was said that they were going to solicit input from the stakeholders and go forward and come up with, doing new rulemaking. And they're in the midst of that process as we speak right now. Understand that that portion, if I take this back to House Bill 51, which you people are interested in, really has to deal with due process. That's what we're talking about, what these educational guidelines, this is all has to do with due process. That was one part of that particular bill. And to answer Senator Orrock's question, until those regulations are promulgated, there's not much point in this committee, at least from the Senate's perspective, certainly going forward and doing anything with this particular bill. And Representative Earhart and I have talked about this. He's familiar with that. And the other thing, though, in the bill, it was talked about mandatory reporting. And again, this is from my own perspective. This is not the committee. This is not the House. This is Senator Miller. As mentioned by Dr. Baxter, there isn't a requirement for people to mandatory report these incidents to the police. I will tell you right now that, based upon my knowledge of the situation, I personally have not been given a reason to make it mandatory. Because again, I think this is a very personal matter. And other than, as mentioned by Pat down here about elderly abuse and certainly for child abuse. But we're not talking children here, okay, by and large. We're talking people of the age of consent, if you will, the age of adulthood. So that's myself speaking going forward. I pointed out because I think it's important to let my prejudices go forward. But I do think it's important to a lot of people in attendance in this room and in just in general. And with that, I'm going to turn the microphone over to Chairman Jaspers and for his comments.
Yeah, thank you, Mr. Chairman. And I appreciate you getting everyone together to talk about this. On the House side, I think this is kind of a interesting situation where we heard a lot of testimony last year and a lot of decisions and a lot of movement. And in doing all of that with Chairman Earhart, I want to commend USG, especially in TCSG, and private schools for really taking what he had to heart and really refining a process that had some flaws, you know, and probably damaged some people. And as Chairman Earhart and I have talked about it, I think he's very complimentary on what's going on and how y'all have moved and I think made a better situation. And I commend you for that. And I also want to recognize, Mr. Chairman, my new Vice Chairman, Bert Reeves. And we appreciate him for being here and taking the leadership role.
That would be your lawyer?
I'll be speaking for.
I've got 5 lawyers on my committee. Some people need that many lawyers. Oh my.
So really at this point, folks, so everybody knows planning going forward, okay? I don't anticipate us dealing with House Bill 51 for the balance of this year because by the grace of God, we will be out of here by the latter part of March. I don't think that the federal government moves that fast. And when those regulations come out, we will probably bring this back up next year. And again, I think it's important, and the reason we held this hearing was to get everybody on the same page, where we are in the state of Georgia. And I would like to also applaud the university system, technical college system, and the independent colleges, first of all, for working together on this particular issue. And for what they've done, I think they've made progress. I think all of us, as lawyers and non-lawyers alike, are a lot better informed than we were on this particular subject. And I'm going to have this young lady up here, I'm sorry, Representative Bentley, I'm going to have you go ahead and make a closing comment.
Yes, sir. Thank you, Mr. Chairman, and thank all of you for attending this committee hearing. We really appreciate you all coming, but I just want to take a moment to recognize Fort Valley State University, Albany State, and Savannah State alumni are in the house this afternoon, so thank all of you for being here.
And it wouldn't be a Senate meeting without Senator Warwick's final comment.
Well put, Mr. Chairman, thank you. Just briefly, I know that the university is entered into a new phase, as we heard today, with a fine tuning, and I'd like to urge them to arrange for student input as that process unfolds over this next year, so that the folks most affected and impacted have an opportunity to provide feedback. The other thing that the audience may be interested in is that there is a bill in the Senate that Senator Parent has introduced, and that would be the result of that bill, were it to pass, would be to fine-tune a process on any sexual harassment reporting and investigating here under the Gold Dome. That would apply both to people who lobby the legislature as well as to the staff and members here. And you may want to follow that bill. Thank you, Mr. Chairman.
Ladies and gentlemen, we thank you for your time, and we are adjourned.
Thank you.
Thank you.